I would now invite Professor Raj to moderate the panel. Over to you, sir.
All right. A very, very good morning to all of you. I would like to extend a warm welcome to all of you to this, the inaugural plenary panel of the American Bar Association's India Conference 2023. We have with us a very distinguished set of judges of the Supreme Court of India. I'll briefly introduce them. But I also want to mention that after a fantastic keynote address by the Honorable Chief Justice of India last evening, who indeed set the tone of the conference, which essentially focused on the intersection of globalization and localization, which has been called by the organizers as glocalization, and how law and legal institutions are playing a significant role for shaping that future. This particular plenary session is indeed another example of how we intend to move in this conference. The title of the session is called Role of Judiciary and the Rule of Law in Advancing Economic Development. Of course, we have, again, as I mentioned before, a very distinguished set of judges, and I will introduce. But before I do that, I want to mention that one of the remarkable things that binds democracies around the world is its strong commitment to the protection of the rule of law. Rule of law is something as a principle, one cannot take it for granted. A lot of efforts need to be constantly made so that all institutional capacities are constantly improved and reimagined with a view to protecting the rule of law. It is also possible that rule of law is fragile when institutions get weakened. And that means that we need to take additional efforts to protect and strengthen the democratic institutions in all these countries. India is no exception. There have been moments in the last 75 years when we've had institutions weakening, and during that time, rule of law indeed got weakened. Here, today, we are going to discuss about the role of one particular institution, which is the judiciary itself. We couldn't have got a more outstanding set of sitting judges of the Supreme Court of India. Before I formally invite and welcome them, as an academic, I've had the privilege to attend, speak, and participate in over thousands of conferences around the world. And having studied in good institutions in India and Oxford and Harvard and Hong Kong, I have been most impressed and even inspired by what these four judges have been doing for the last 72 hours. Believe it or not, this particular panel that we're having today, we have had 2 Zoom sessions, in-depth discussions in preparation for this panel. Despite the fact that all of them have sat through the court in the day, they attended this Zoom session, which I did not call, they called it, and we had extensive discussions in preparation of the panel. For all the students here, something to learn about what these judges have done. We have with us Honorable Mr. Justice Surya, Judge of the Supreme Court of India. I'll very briefly introduce him. Justice Surya was designated as a senior advocate in March 2001. He earned distinction of being appointed as the youngest Advocate General of the state of Haryana, where we in Sonipat are located, in July 2000. He held the office of the Advocate General Haryana till his elevation as a permanent judge of the Punjab and Haryana High Court in January 2004. He was elevated as a judge of the Supreme Court of India on 24th May 2019. We have with us Honorable Mr. Justice Ravindra Bhat, who is also another judge of the Supreme Court of India. Justice Bhat practiced in the Supreme Court and was enrolled as an advocate on record in 1989. He practiced in the broad fields of public law, employment, education, and constitutional disputes, and in several important cases, he stood before the constitutional benches of the Supreme Court during his legal career. He was appointed as additional judge of the Delhi High Court in July 2004 and a permanent judge on 20th January 2006. He was elevated as a judge of the Supreme Court of India in September 2019. We have with us Honorable Ms. Justice Bela Trivedi, who is a judge of the Supreme Court as well. Justice Bela Trivedi was appointed directly as a judge of the City Civil Court and Sessions Court in Ahmedabad in July 1995. We should also mention that it was a happy coincidence that her father was already working as the judge at the City Civil and Sessions Court when she was appointed. Quite remarkably, the Limca Book of Records has recorded the entry in their 1996 edition that father-daughter judges in the same court, working on different posts such as Registrar Vigilance in the High Court, Law Secretary in Civil of the Government of Gujarat, CBI Court Judge, Special Judge in the serial bomb blast matters. She has had a very wide experience of both civil, commercial, as well as criminal matters. Justice Trivedi was elevated as the Judge of the Supreme Court of India in August 2021. We have with us Honorable Mr. Justice Sanjay Karol, who is also the Judge of the Supreme Court of India. Justice Karol was appointed as the Chief Justice of the Patna High Court in November 2019. Previously, he served as Chancellor of Patna's Chanakya National Law University and was also a Patron-in-Chief at Bihar State Legal Service Authority and Bihar Judicial Academy. Justice Karol was elevated to the Supreme Court of India in February 2023. I want to stop here and we will quickly move towards the panel. What we want to do is that I'm going to request each of our judges to give an introductory remarks broadly reflecting on the theme of the panel, which they can actually do it from the podium itself if they choose to. And followed by that, we will have a kind of a Q&A session with me as the moderator and followed by a short Q&A session with the audience as well. This is how we'll proceed forward. With those words, I'm going to request Honorable Mr. Justice Surya, Judge of the Supreme Court of India, for his introductory remarks. Thank you.
A very good morning to all of you. My esteemed brother and sister judges on the panel, Professor Raj Kumar, distinguished audience. Just as a brief reference, and most of you are fully aware, the Indian Constitution is a historical script born from the experiences gained during the long freedom struggle with a promise to respond to the aspirations of the Indian masses and to eliminate their sufferings, inequalities, and atrocities. It was not just meant to be a commemoration for a nation's struggles for independence against colonial powers, but it also attempted to spark and shape the social fabrics in order to achieve social, economic, and political justice as we promised in our preamble. The Constitution, by incorporating fundamental rights, radically pushed the nobility from the position of privilege and created a framework to empower lower castes and tribal groups. It laid down directive principles which, although not justiciable, imposed a duty on the government to improve the welfare of the citizens through the broad powers of the modern administrative state. It is in this backdrop that the role of judiciary assumes significance. Judiciary had an enormous responsibility to ensure that the rights of poor and marginalized classes are duly protected, equality is guaranteed, and their life and liberty is maintained at any cost. For this, the Indian Supreme Court crafted an expansive fundamental rights jurisprudence, particularly under the right to life, starting from old Khadak Singh judgment, which recognized the life under Article 21 meant more than animal existence, which then ushered three separate forces, namely expansion of personal rights, such as in Sunil Batra or Menka Gandhi's cases. Second, expansion of socio-economic rights, such as in Olga Tellis and right to food, educational jurisprudence. And the third was protection of common resources and right to sustainable development, as recognized in our environmental jurisprudence. The basic foundations in our Indian Constitution have been carefully protected from time to time by the judiciary through judicial intervention, which has gone deep into not only in resolving civil and private disputes in respect of personal liberty, but even the legislature or political decisions. When it comes to the rule of law, it is a fundamental principle of modern legal system that establishes the foundation for fair, just, and democratic societies. Its core principles include supremacy of the law and equality before law, both of which are required to be maintained by a well-oiled judicial system through consistent, fair, and non-arbitrary application. Hence, adopting a fundamental rights-sensitive approach allows legislative reforms and assists institutions ranging from penal systems to courts and parliament to better implement the constitutional vision, as I discussed before. It also promotes good governance initiatives through measures such as participation, transparency, and responsiveness of civil society, which affect the development of the economy. Independent judiciary ensures predictability of governance, which is good for public policy. In the longer run, efficiency and honesty of government is maintained, which is necessary for economic development. All these variables of governance ultimately impact development to greater or smaller extent. To put it simply, a citizen-centric approach sensitive to our constitutional vision promotes good governance, which further leads to development. Therefore, the proactive role of the Indian judiciary has effused a sense of confidence nationally and globally. This has been proved beyond any doubt by the fact that India has applauded for its efforts in global development and economic stability during these challenging times. It's well within the public domain that India is the fifth largest economy in the world as per the exchange rate and the third largest as per purchasing power parity. No doubt, these are the positive results of good governance, but this position of economic prosperity cannot be sustained unless there is the rule of law. The judiciary will remain the sole harbinger of the rule of law, provided that it continues to command the trust of the general public as it has maintained throughout its history. Thank you. Thank you very much.
Good morning to all of you. Thank you for the invitation, Dr. Raj Kumar and the organizers. I'm delighted that this event is being held after 6 years. The COVID pandemic was a break which inhibited the interaction physically, but I think now we are back with a vengeance. A lot of these events are taking place. I'll come straight to my presentation. The Indian judiciary is tasked with the role of a neutral arbiter. Its judges at the superior level are afforded constitutional status and assured independence. We gained our independence and our freedom struggle after a prolonged fight, after a prolonged struggle. It took us about 30 years to reach that. And we were very committed and determined in our resolve that we will have a society which will rid itself of its past inequalities, and that the greatest number of citizens will benefit, and that the state aim would be for that purpose. And yet one must sound a note of caution, which is that the Constitution does not have any ideology. It accommodates the thoughts of the day, and it is in that sense a forward-looking document. The role played by the judiciary in the country in the economy and in our country is vital. First and foremost, it is the upholder of the rule of law, which means many things. When it interprets a law which deals with liberties, it has the foremost in its mind the essence of that liberty. When it deals with matters of social welfare, the object of that law is taken into consideration. When it deals with economic legislation, what is the object which the state wishes to achieve is paramount. Our country initially was a centrally planned economy where the government was a regulator and an actor, and in many cases also a monopolist. It has now retreated to being a facilitator and supports regulatory regimes. This change has resulted in reorienting the judiciary's role while not essentially impacting its adjudicatory role. One consistent principle which the courts have adopted is that in fiscal, economic, and commercial policies of the state, there is a stricter scrutiny, of the federal government, there is greater deference to policy. This is in contrast with the case of individual liberties, where there is stricter scrutiny of policies and how they impact liberties. However, unless the impact is per se or palpably discriminatory, the courts would not interfere with the laws, the legislations, or executive's policy. In the recent past, in the last 3 decades, the country has transformed from a largely public sector-driven economy to an open economy. Its regulatory regimes in the financial, securities, telecom, and energy sectors are all well established. They have evolved over a period of time. The courts also increasingly deal with arbitration disputes. India is a signatory, one of the earliest signatories to the New York Convention, and more recently to the UNCITRAL model law. It has aligned its laws with UNCITRAL basic law. There are several arbitration institutions in the country. Besides, for speedy resolution of disputes, Parliament has also enacted the Commercial Courts Act. At the central focus of this is the courts and how they interpret these laws and facilitate the transformation of our country from a public sector driven or let's say a centrally managed economy to a largely private economy. There, as I said, the court is a neutral arbiter, first and foremost guardian of liberties as and when they are impacted. In other cases, it facilitates the policy, it facilitates the objective of the law. The courts have been very creative in evolution of various substantive principles in public law. There is a substantial and robust judicial review system in place which emphasizes on the core values of fairness, reasonableness, proportionality, and non-discrimination in judging executive action. This expanded judicial footprint in public law is on account of innovative interpretations, such as the citizen's right to avail judicial review even against actors who may not be the state, but whose duties are public and they impact private rights or individual rights. In the field of remedies also, the Supreme Court has shown great innovation, especially when its interpretation is likely to change how one's affairs or business can be arranged, tailoring the decisions narrowly or ensuring that the adverse impact is not felt disproportionately. One striking example is when the court went back and reworked the previous arbitration law and declared how the arbitration law had to be interpreted. The court realized that its interpretation was likely to create virtually a tsunami in the arbitration world and in the world of contracts. So the court said the decision would be applied prospectively. In the field of technology, the Supreme Court and the courts in India have been pioneers and I would say even spectacular innovators. The National Judicial Data Grid is the world's largest single data judicial grid, which contains details of all cases of all kinds pending on all the courts. It also tracks real-time progress of each case and has eased information dissemination to litigants. Similarly, the courts played a singular role in ensuring access to justice through video conferencing hearings during the entire COVID-19 pandemic period. Judges, court employees, advocates, and litigants did not have to go to courts. Video conferencing hearings were facilitated. During the period March 2020 to February 15th, 2023, about 413,537 cases were heard through video conferencing facility by the Supreme Court. Out of these, 102,468 causes were disposed of or closed by final orders. On the whole, during this period, 5.2 million cases were filed and 4.22 million cases were disposed of through video conferencing by a 23,000 strong judge strength in the country. This shows the robustness and resilience of our system, which has been able to not only adapt but innovate in the teeth of most formidable challenges. And as we now are completing our 75th year of independence, I think we have to rededicate ourselves to the goal of upholding the rule of law and also fulfilling the people's aspirations. Thank you.
Namaskar and very good morning to all of you. dignitaries on the dais, off the dais, esteemed guests, and friends. Earlier, we used to say, think globally, work locally. Now we say, think globally, work globally. I think that is the motto of this conference also. And that reminds me of our ancient phrase, Vasudhaiva Kutumbakam. The whole planet, Earth, is nothing but a family. And therefore, when the whole world has become global village and one family, how one can be happy when others are not. That is also probably the culture of African tribal people that I am because we are. So I think since we all are facing the challenges globally because of the proliferation of technology and economic field, probably we all will have to find out some solutions which are amenable to all. The present conference also assumes great significance when India is hosting G20 summit, which aims at increasing trade and investment in the key drivers of growth in the world, grappling with recent devastation of COVID-19 pandemic and Ukraine war. In the present scenario, India is seen and expected to be the fastest growing, largest economy in the world. When India is seen as the bridge between developed and developing countries, India also looks forward to focus on areas where it can bring structural transformations, propelling growth, prosperity, and equity, and in turn, to contribute solutions to the global challenges. Economic growth and economic development, though sound similar, there is a significant difference between the two. Economic growth is relatively a narrow concept. It entails quantitative increase in the output, that is national income. Economic development includes qualitative changes such as social attitude and society's material well-being, in addition to quantitative economic growth. The major factors which can spur economic growth and economic development in a nation are broadly human resources, natural resources, economic policies, development in technology, development in infrastructure, capital formation, internal security, international relations, and so on. Let me say that India is a democratic country with largest population and great diversities in caste, culture, religion, language, heritage. India is also an agriculture country and possesses vast fertile lands and numerous perennial rivers. There is no dearth of human intelligence in India. The natural and human resources responsible for economic growth are in abundance, and that is one of the reasons India has become the fastest growing economies in the world. In the last 60 to 70 years, economic policy of India has traveled from laissez-faire to mixed economy to the present era of liberal economy with regulatory regime. However, since last few years, the Indian economy has experienced major policy changes on LPG model, that is liberalization, privatization, and globalization. This LPG model has its own challenges in the domestic as well as global market. These challenges have different shapes and different contours, and they have to be dealt with in different manner. When the issues having economic repercussions come to the courts have to deal with the same, having regard to not only the legal aspects, but also the demographical, geographical, and cultural aspects. So far as the role of judiciary in the advancement of economic development is concerned, I would say that it has been very significantly progressive and constructive all throughout. Just as supremacy of law and rule of law, the powers of judicial review has also been treated as and recognized as one of the basic features of the Constitution. The judiciary in India is not only independent organ in a democratic setup of government, but is also very vigilant in implementing the rule of law, which is the hallmark of egalitarian society, and therefore the role of judiciary at all levels has become very pivotal. Of course, the powers of judicial review, as Justice Bhat elaborated, in the matters pertaining to economic policies of government are exercised with great restraint and caution. The consistent view taken by the Supreme Court in plethora of cases has been that the courts should feel more inclined to give judicial deference to legislative judgment in the field of economic regulations than in other areas where the fundamental human rights are involved. The wisdom and advisability of economic policies are ordinarily not amenable to judicial review unless it is demonstrated that policy is contrary to any statutory provisions of the Constitution or is patently arbitrary or malafide. It is not for the courts to consider relative merits of the different economic policies and to decide whether a wiser or better policy could be evolved. The function of the court is to see that the lawful authority is not misused or abused. It is not the function of the courts to appropriate to itself the task entrusted to other statutory authorities. By and large, the approach of the judiciary has been that the matters of economic policy must necessarily be left to the expert bodies who are qualified to address the issues, since the economic and fiscal matters are exclusively within the domain of government. Of course, some of the landmark judgments of constitutional courts have made huge contribution in the advancement of economic development, and they have reshaped the financial landscape of the country. For example, the judicial pronouncements on nationalization of banks, taxation, demonetization, RBI's control over banks for regulation of cryptocurrency, pronouncement on privatization, disinvestments, foreign investments, international commercial arbitrations, infrastructure development, on cyber crimes, and many other matters. All these matters have had large impact on the economic development of the country. The technology and globalization continue to uproot and reshape our daily life and economies. Our existing legal infrastructure, our existing rules, our existing approaches need to be updated to meet with the new challenges thrown at us by the complex and advanced economies. The legal minds and legal professionals need to reinvent themselves to find out new laws, new global legal systems for complex and contemporary economic globalization. Just as nation-building work is being done by different organs of the government, the global work will have to be done by the nations individually and also collectively. Thank you so much. I thank Justice.
Good morning, all of you, ladies and gentlemen. To be a co-panelist amongst the galaxy of my distinguished colleagues, Honorable Mr. Justice Surya, Honorable Mr. Justice Bhat, and Honorable Madam Trivedi, is indeed a matter of great privilege and honor. Quite honestly, I am not quite sure why Professor Raj Kumar chose me to be one of the panelists. But nonetheless, I thank him for definitely from these deliberations who would stand to be educated. I must congratulate the American Bar Association. Yesterday I was here and I heard each one of you speak brilliantly. Your views very, very forthcoming and very enriching. And the Honorable Judge who has come from Hawaii, I take your invite. Definitely, I'll come and visit you there, please. I would skip what has already been touched by my erstwhile distinguished colleagues. Normally, judges speak only through their judgments. And therefore, Professor, pardon me if I maintain the right of silence when you question me during the session. Friends, when the Constitution was being promulgated, our constitutional forefathers had foreseen the role of judiciary in protecting and promoting core human values such as equality, fraternity, and liberty, which were to be cherished by all, one and all. I repeat, one and all. With the values of socialism and secularism being added later on. This has been brought about in the preamble of the Constitution, which says that the people of India, having resolved to secure to all its citizens social and economic justice. Therefore, the preamble attains significance in today's deliberations. It is in this context that independence of judiciary is paramount and is a sine qua non for any democracy to function with prosperity. A strong, independent, and well-meaning judiciary with integrity is the bedrock of any democracy. This is one of the reasons why judiciary in India is called third pillar of democracy, and Indian people have great faith in the justice delivery system. There is a saying, colloquially, they say, whenever there is a dispute, ke court mein dekh lunga, I'll see you in court. So that only reposes great faith which people of India have in the justice delivery system. Every judge and the judiciary collectively stands tall while performing its role as the sentinel on key way, as well as nurturing and advancing constitutional morality. In a democracy, rule of law is ensured when the judiciary works with a strong free will, promoting individual and economic interest in tandem, which of course has to be in national interest. For after all, nation is paramount. There is a positive correlation in the economic growth and rule of law. Hence, justice has to be distributive, affordable, and expeditious. For any delay impedes economic development and obstructs rule of law. The role of law is undoubtedly the golden thread of world order. It is that essential piece of equipment, if you will, that the facilitates smooth functioning on the various factors, aspects, and components that make up this global village. This thread binds the entire Constitution. The Supreme Court of India, time and again, has reiterated the principles of rule of law, applying it in different fact situations. I need not repeat what Honorable Justice Surya said about Khadak Singh and Maneka Gandhi. All I got to tell us, Shreya Singhal and Puttaswamy are other examples amongst them, where it is not the words of law, but the spirit of the Constitution and the principles thereof, which are of utmost essentiality. In the National Legal Services Authority judgment, former judge of Honorable the Supreme Court of India, Dr. Sikri, who would be sharing the dais in one of the programs, as I see from the brochure, observed that rule of law is not merely public order. Substantive rule of law is that which strikes a balance between society's need for economic development, political independence on the one hand, and the needs of the individuals on the other hand. It is the duty of the courts, hence, to protect this rich concept of rule of law. Today, it gives me immense pleasure to state that free legal aid is growing at a remarkable pace in our country. For instance, in the Lok Adalats, organized by the National Legal Services Authority and through the digital platform which was just mentioned by Honorable Justice Bhat, more than 1.27 crore cases were disposed of, justice dispensed without requiring recourse to expensive litigation. Judiciary, and these are my personal views, is a stakeholder in democracy. For a democracy to be fully realized, an important aspect is poverty, which is undoubtedly one of the major issues that plagues more than half of the world. And it is this backdrop I see that the deliberations of this conference would go a long way in elevating the sufferings of the people. When a positive correlation of economic development and speedy justice has been established, the role of legal aid institutions acquires profound importance. And this I am saying so for the reason that prior to my adorning the bench of Honorable the Supreme Court of India, I have had the good fortune of having administered 3 states. Those in the need of legal assistance from the bar and the legal institutions are also those who are at the lowest rung of the economic ladder. I emphasize the role of the bar in ameliorating the sufferings of the people of the world. And surely, if I may now end by stating that the deliberations of this conference would acknowledge the rights of the downtrodden and find solutions for them. Jai Hind.
Thank you very much, Justice Karol, for those reflections. Now we will move into a kind of a dialogue with our distinguished judges. I believe we are live on NewsX as well. Let me come to Honorable Justice Surya Kant. Justice Surya Kant, an American jurist, Justice Holmes, very famously remarked that the life of law is not logic but experience. In a very interestingly different vein, but conceptually similar, where Dr. Ambedkar in his last speech at the drafting committee talked about the fact that we have a great constitution, but its future will depend upon how we man it and not necessarily because of how good it is. So my question to you is that in the last 75 years of the evolution of Indian judiciary, what do you think were the key features that informed and enabled the establishment of a rule of law society in India?
Well, as I said, my introductory remarks also, the evolution of Indian judiciary since independence, I would say, has been shaped by various factors, which included legal, political, social, and economic considerations. The most important among them was the constitutional vision, as you rightly pointed out, referring to Dr. Ambedkar, and later onwards the constant political and social changes such as globalization, the era of internet, has informed our viewpoints. The impact of all these, I would say, has resulted in development of three aspects for building a rule of law society in India. The first and foremost, I would say, the independence of judiciary. My brother Justice Sanjay Karol also very briefly pointed out, and so was my other brother and sister. The Indian judiciary has evolved to become increasingly an independent of the executive and legislative branch of the government. It was not only a constitutional philosophy which is reflected in Article 50 of the Indian Constitution, but I would say that in a 75 years of long journey, the Indian judiciary has well established itself as an independent organ working independently, impartially, fairly, with a view to uphold the rule of law and to protect the rights of the citizens without political or executive interference. When you talk of the political cases of old cases, I am referring to some instances of Raj Narayan or S.P. Gupta, and there are several other instances where the Indian judiciary has really shown and proved its worth as an independent institution. The second important aspect is the access to justice. The Indian judiciary has evolved a mechanism, and in some of the other countries also, I know that I am aware that it's available, but I must point out that keeping the socio-economic conditions prevailing in the country, where poor and marginalized people, sometimes on account of poverty and on account of social and other economic disabilities, are unable to have access to justice, we have evolved a very robust system in India through the platform of legal aid, free legal aid, the legal aid clinics, and also through alternative dispute resolution mechanism in order to provide free or subsidized legal services to all and one. The other concept the Indian judiciary has really evolved, and which was not a very well-known phenomena in the other jurisdictions, is the public interest litigation concept. I think 1970 late onwards, we have introduced this concept, and that even a person, mere communication to the Supreme Court, pointing out the violation of any kind of fundamental rights or human rights, that simple communication was taken as a list, and the court took cognizance, and those matters have been effectively and authoritatively adjudicated. That's also a very landmark achievement I would contribute to the Indian judiciary. And the second facet of this very concept is the judicial activism. I'm aware that sometimes the judicial activism is being unnecessarily misunderstood in a different way. But judicial activism is only the judiciary has come out as a conscious keeper of the rights of the people. And that role, I would say, in 75 years, the Indian judiciary has significantly and successfully played.
Thank you very much, Justice Surya Kant, for really outlining the role of the Indian judiciary. Let me move to Justice Ravindra Bhat. Justice Bhat, the Constitution of India, of course, clearly has provided a very robust protection of rights and freedoms. But we also have recognized the role of legislature and executive and judiciary. Separation of powers doctrine has been deeply embedded in our constitutional culture. But quite remarkably, the judiciary alone as an institution has also been given the power to declare a law unconstitutional. Now, can you reflect on this aspect of the role of judiciary, which inherently helps in judiciary in many ways performing a function whereby it is actually evaluating and testing the constitutional permissibility of legislation and administrative action?
Thank you, Dr. Raj Kumar. If you look at the way the courts have discharged the role which you have asked of me, the earlier judgments in the, let's say in the 50s and 60s, the court's time was taken in interpreting the Constitution in the context of welfare laws, which were largely expropriatory. So the debates went around what is meant by compensation. So it turned out to be quite a, let's say, a kind of a dialogue which turned acrimonious at times. But eventually in this process, the court was able to expand the scope of liberties. But all along the court, at the same time, the Supreme Court has been, it's been using something like a sliding scale principle, like you have in the United States, where the sliding scale principle in the United States, while evaluating the law, is when it deals with individual liberties, the scrutiny is the closest. Therefore, the threshold for passing the law should be, or intolerance is the lowest. When it comes to intermediate, that some kind of welfare laws, you allow the state greater latitude. And when it comes to economic, pure policy and economics, fiscal policy, the state has the greatest latitude, and you would not get into the business of classification or how it impacts individuals, as Justice Trivedi mentioned in her presentation. So the court has been playing an extremely balanced role in this. One of the, that's one. The second is, one of the core markers of this evolution, evolution of principles has been the injection of the principle of fairness, proportionality, and what is called as, in judicial terms, tailoring the relief, which meets the solution, meets the particular ends of that case. Fairness has several aspects, and one can't go into it. As lawyers, the audience knows what is fairness, but shortly put, it encapsulates all elements of natural justice: notice, hearing, reasoned order, an opportunity to be heard, etc., and a fair decision. So this principle of fairness has been injected through progressive judicial interpretation. Now, even though the law may be upheld, the impact of the law and the manner in which the decision maker arrives at a particular policy, or certain interest groups or certain individuals' expectations are not met with. In such event, how does the court deal with it? The court need not necessarily strike down the whole policy. The court, if it's an individual impact, it may say, I'll set aside this order. But if it's a matter of policy, it may send it back to the policymaker to rework it rather than strike it down. So the court has been conscious of its role in the separation of powers doctrine. But when it comes to liberties, there is no compromise. If, as Justice Surya Kant said, any law violates a core constitutional value, especially a fundamental right, then there is no question of the court having any two opinions about it. I hope that answers your question.
Absolutely. Thank you so much. Thank you so much, Justice Bhat, for that. Let me quickly move to Justice Trivedi. Justice Trivedi, one of the things that the constitution makers were very conscious of was that even though we have a robust constitution for protecting rights and freedoms, they also expressly provided the access to constitutional remedies to writ jurisdiction, something that enormously expanded what we call the democratization of access to justice. Can you briefly reflect on this aspect of how writ jurisdictions have enabled the citizens' access to justice?
Thank you, Professor Raj Kumar. As we know, Part 3 of the Constitution deals with the fundamental rights, and Part 4 deals with directive principles of state policy. The access to justice and access to constitutional remedies itself has been included in Part 3 of the Constitution, and that has been made the fundamental right of the citizen. So apart from the High Court's powers under 226 and Supreme Court's power under Section 30, Article 32 to enforce the fundamental rights, the Supreme Court has the powers under Article 142 they are called plenary powers, to pass any order, to do complete justice. And that is the reason why the public interest litigations have been entertained in the courts for the enforcement of any fundamental or human rights, though not included specifically in the Part 3 of the Constitution. There have been judgments consistently since 1970s that public interest litigations have been entertained without any technicalities, like whether he's an aggrieved party or not, whether the person has any locus standi or not, whether it is in a proper format or not. Even the postcard has been treated as a petition. And the rights like speedy trial, right to livelihood, right to clean environment, though free legal aid, all rights, though included in directive principles of state policy, which are not enforceable at law, they have been treated as concomitant fundamental rights, and that's how the right to access to justice has been extended.
Thank you very much, Justice Trivedi, for that. May I request now Justice Karol. Justice Karol, one of the things that we have seen in India is that the ordinary Indians have extraordinary faith in the judiciary as an institution. The credibility and the legitimacy of judiciary and judges are quite significant, unprecedented compared to even other democracies. Now, my question to you is that, how does this have a direct impact on the ability of judiciary to adjudicate on matters that have social and economic significance? Almost the legislature executive might even prefer that the hard decisions are taken by the judiciary as opposed to they becoming unpopular.
You know, to begin with, I'll say that it never weighs in the mind of the judge whether any decision is hard and affects any which way the executive, political or otherwise. As I had said in my keynote address, that we are absolutely independent and we work only for the welfare of the people and within the framework of the Indian Constitution. Adding further, I was to also say that people have great faith in the justice delivery system in India. I would also add this, that when we have these discussions, we must also account for the greater part of our population which are the have-nots. And therefore, when we are talking of, socio-economic justice, we must account for the ground realities. After all, sitting here in Delhi, in this great environment, we cannot even encompass, imagine the hardships which those people would be facing. And for them, rule of law is nothing but, giving them what is due to them, be it by way of, the examples I would give would be very mundane as far as this conference is concerned. But as I said, that having headed 3 different jurisdictions, illustratively, I'll just, point out, in Bihar, the matter is no longer sub judice, so therefore I can talk about it. We realized that there was a huge dropout rate of children, especially girl children, from schools. So we conducted a survey and we wanted to find out what would be the reason. Could you understand, it was beyond comprehension that there were no girl toilets, much less, sanitary mechanism for, sanitary disposable systems. Even otherwise, speaking, the unorganized sector, for example, the truckers, who are giant, who play a great role in pushing ahead the Indian economy, apart from the railways, they're great movers. No one even thinks about those, who carry our goods, transport our goods from one end to another. They are, according to me, the backbone of our whole ecosystem and environment. So therefore, we have to shift our approach from metrocentric to that of, urban-centric. That's how I would say.
Thank you very much, Justice Karol. Let me now move to Justice Suryakant. Justice Suryakant, one of the things that the judiciary has done is that it has not hesitated to move into areas of public policy in particular, especially reviewing issues surrounding policy in relation to its constitutional permissibility. Of course, at one end, we have what Justice Karol talked about, where the judiciary is looking at policy and looking at its effectiveness. It's not a unique thing. We had the Brown v. Board of Education matter all the way. US Supreme Court had done its own role to move towards building a diverse and inclusive society. In your view, where does this role of judiciary in evaluating administrative policy in line with its constitutional permissibility takes place?
Well, the power of judicial review is well recognized in the Indian judicial system and within the framework of the Constitution, whether it's Article 32 for the Supreme Court or 226 for the High Courts. And I must say that the Indian judiciary plays a very crucial role in ensuring that the administrative policies are in conformity with the constitutional philosophy. And there have been numerous instances, it will take time to quote even a few examples, but there are numerous instances where the courts have struck down, the courts have interfered, wherever the policy decisions were found to be not consistent with or in conflict with the constitutional philosophy, whether it's fundamental rights or maybe even some other provisions of the Constitution. Having said that, I must also say that as far as the commercial matters are concerned, the judiciary has a very innovatively a very restrictive role we have evolved for ourselves. And as you know, the famous in Tata Cellular judgment and onwards, we have said that unless the policy is found to be clearly violating the well-established principles of reasonableness, or it's really hit by Article 14, then only question of interfering with the policy would arise. I would also just supplement by saying that in the matters where the national interest or larger public interest, some policy decisions are taken, the courts have been reluctant even interfering those policy matters also. You can start way back when the nationalization of the banks took place, or when the Balco matter came, where the privatization of a government company, the policy decision was taken. All these decisions were upheld, and the courts were reluctant to interfere in those policy decisions. So the basic yardstick and the benchmark is that if the policy responds to the constitutional requirements, the courts seldom interfere in those.
Thank you very much, Justice Suryakant. I'm conscious of the time. Although this session is going to end in 18 seconds, I know the next one is a coffee break. I am going to skip the coffee break, and we're going to gain 15 minutes without compromising the next session, so we will continue the discussion. Over to you, Justice Bhat. Justice Bhat, one of the things that has happened through this evolution is that the role of the state has expanded. For a long time since independence, the state was performing all kinds of activities, and a lot of that activities have moved into the private sector. In that changed evolution of the state and its role, how does judiciary perform its own role in dealing with private actors?
I would say that the question itself is very fascinating. As I said in my initial remarks, the judiciary has and continues to reorient itself to these new realities. At the same time, there are certain, let's say, values which it identifies in this march, in this progress of our society. For instance, when it came to the value of transparency, when it came to the value of right to education, or when it came to the certain other, like food security. Or even, for instance, you're looking at sexual harassment at the workplace. The privatization or retreat of the state from the economy did not deter the courts from doing what the court thought was right after identifying a core value. For instance, in the case of sexual harassment, the court, in the absence of a law, put in place a number of guidelines. Now, this is where social consensus is important. And I believe that there was a social consensus which supported the decision of the court, even though there was no law, even though there was no executive policy. Ultimately, a law was made by Parliament. Likewise, in the case of right to education, a child's right to education, it was transformed from a directive principle to a right to education articulated through judgments. Eventually, the Constitution was amended and a new provision was brought in to facilitate that judgment. So we have these spectacular examples. But coming back to the core, the main question which you have addressed to me, which is how has the court reoriented itself? Again, I think the takeaway would be the same. Wherever there is a law which furthers a particular goal, a commercial or a economic or fiscal objective, the court will identify the public interest involved, weigh that against the individual interests, and by and large, the court has gone by the executive or the parliament, upheld it. At the same time, the court has been prodding the legislature. For instance, when the economy opened up initially, you did not have regulators, and yet the state was also a competitor. So therefore, the court judgments facilitated growth of the regulatory regime. And I believe one of the most celebrated regulatory regimes which has been in place is the telecom sector, which has been mirrored in electricity, in the energy sector, etc., and other sectors. So here, the role of the court is very crucial because it is that of a complementary, because the judgments of the court led to the change in law, the setting up of these regulatory mechanisms, and also adjudication in those areas of the economy, which ultimately upholds the rule of law. I hope that answers your question.
Thank you very much, Justice Bhat, for so beautifully answering the question, but also setting the stage for Justice Trivedi's question. Ma'am, one of the things that has happened is that with this evolving changes in economy and development, courts are going to be called upon to make significant determinations, including dispute resolution on a number of matters. My question to you is that, how does this change in the economic structure is going to impact the role of the court, especially when it comes to commercial disputes and other forms of mechanisms that the court will be asked to adjudicate?
Thank you, Professor.
Yeah, it's working.
There is no doubt that there is a need to reinvent ourselves because the present legal system, present legal infrastructure is not sufficient to deal with the new challenges, new demands, new aspirations which the people have from the courts. The interface between the economics and the law also has become very relevant in the present scenario when India is ushering into the globalization, more particularly in economy. And one of the key factors for attracting foreign investments would be to have cost-effective, speedy justice they would be expecting. Apart from courts, we have alternative dispute resolution mechanisms, and courts have been encouraging international commercial arbitration. We have the Arbitration and Conciliation Act in force, which gives so much of autonomy to the parties to decide the place of arbitration, to decide the procedure to be followed during the course of arbitration. The enforcement of foreign courts awards like that. And apart from that, if India is aspiring to become hub for international arbitration, then probably we'll have to do more homework for establishing more and more international commercial arbitration centers. We do have at few places like Hyderabad, Delhi, Bombay, but we need to have more and more such centers in place. And also, we have other commercial courts to deal with contractual and commercial matters. The courts are also ready for digitization, and probably we are prepared to face the challenges which are expected in maybe few years.
Thank you very much, Justice Trivedi. Over to you, Justice Karol. A very similar question, but I wanted to reflect a bit on ADR in particular, arbitration, mediation, conciliation, because if you look at the evolution of such mechanisms in other jurisdictions, a lot of difference has been actually paid by courts so that these mechanisms are also adequately empowered, and the business and industry rely upon these mechanisms for dispute resolution.
The law is there. Last 2 decades, there have been amendments in various statutes. There have been new enactments. Systems are in place. Initially, it did not take off. For the simple reason that there was a confusion, and everyone thought that this law, commonly termed as ADR, was thrust upon us. That's what was the perception of both the bench and the bar. The difference between the conciliator, the difference between the mediator, and the difference between the arbitrator was not very, very clear. It is only by way of continued training that one could understand, comprehend, and work rather fruitfully in that direction. In my considered view, we have come a long way. We moved ahead. As far as commercial dispute resolution mechanism is concerned, that is now fully in place, is operational, and is working effectively. But again, I would put it that ADR mechanism, when it comes to resolution of disputes, not only with regard to commercial matters, but all sort of matters, the bar has to play a bigger role in this. And unless and until there is continued effort on the part of the bar, this drive may not be able to achieve the desired result. Therefore, this conference itself, I would say, is a part in that, step in that direction. Thank you.
Thank you very much, Justice Karol. We are indeed coming to the end of the session, so I'm going to have one question to all of you, and I know all of you will have a good view about it. Let me start with Justice Surya. We recently came to know that we have approximately 50 million cases that are pending in Indian courts. And this inordinate delay that ends up being caused in our dispute resolution mechanism has had a profound impact on business and industry. Now, it is, of course, everybody's knowledge that our judges work very hard and tirelessly slow with little or no vacation, and they end up devoting so much of their time as the dockets are large and the demands and aspirations of the litigants are huge. My question to each one of you is that, what do you think we can do to significantly change the paradigm whereby these delays can be reduced and business and industry in particular, but also other litigants are able to have an easier and a less time-consuming access to justice? Each one of you, the same question, starting with Justice Surya.
Well, very quickly, I will say that a multi-pronged approach is required to deal with this issue. But I will also put a caveat that let's not consider that every case which is filed in court must be taken into account in the pendency. There is that we need to correct ourselves on that issue. A case which is filed in court today and it is registered as a case, whether it's criminal side, civil side, commercial side, whatever may be the nature, must not be counted towards the areas pending, because there is an adversarial system which has a procedure to be followed, and ultimately, unless the case is ripe for the arguments where it's finally in the queue and waiting for its turn for adjudication, I think we may not count it in the areas. But having said that, there is no doubt about that there are areas and that issue need to be dealt with. But some of the suggestions which very quickly I would like to give is that we need to improve the judge population ratio in India. We have, I think, about 16 judges per million right now, and in 2012, the recommendations were for 50 judges per million population. I think that is one of the factor. Second, I would say that as Justice Karol had pointed out with regard to the popularity and acceptability of the alternative dispute resolution mechanism, that really needs to be popularized, and people need to incentivized towards this kind of system. We have now a very effective arbitration system in India. We have also introduced the mediation as a formal law now in 2021, and I think all kind of whether lok adalats or other mechanisms need to be really evolved for quick disposal. The another thing which I will strongly recommend is that we need to have specialized courts. Like commercial courts, we have been able to very successfully achieve good results in disposal of the commercial litigations very quickly. And the stages of different kinds of one appeal or second appeal, those have also been eliminated. Now there are not multiple appeals against the one decision. So that will also provide a very quick final disposal of the litigation. The third thing I would say, we need to sensitize the general public also with regard to their rights, and because sometimes there are some litigations which can be avoided and those can be, even at the pre-litigation stage, those can be resolved. So this kind of various kind of steps are required to be taken at different levels. And this is how I think a lot of professionalism training and judicial training of the judges at different levels is also one of the factors that can really contribute in this regard. Thank you.
I think there is not, I can only think of adding a few things, which is that some of the laws which Parliament has made has been impactful. For instance, the Commercial Courts Act, in cities which see a large number of filings, commercial courts have been set up, and the statistics show that on an average, what used to take about 3.5 to 4 years for decision has come down to about 306 days on an average. Now that shows that it's possible to do it, but the flip side is that when you enact a law and do not increase the judge strength, invariably a lot of judicial talent is diverted to these specialized courts, which means that correspondingly there has to be increase in judge strength. And the second thing which Justice Surya Kant made a very important statement, which is that the judge population ratio has to be increased. I would only say that we need not have a stereotypical view on that. We may have to increase the judge strength in areas where, or geographical areas where there's significant pendency for a long period of time. There could be places like, for instance, in Justice Surya Kant's own home state of Haryana or Punjab, where the pendency is low and the areas are not very high. Likewise, some of the states are doing well. So therefore, to have an all-India approach might actually take away resources. And thirdly, and I would end with this, we have to develop a scientific method of assessing impact of new laws. One spectacular example is the Negotiable Instruments Act. The Negotiable Instruments Act has led to filings which run out to close to maybe 1 million cases every year. These are injected into the system, and the same judges are struggling with this. And I would lastly end by saying that, like in the case of training of judges and prosecutors, there has to be judges and lawyers, there has to be training of prosecutors, so that, and professionalism there, therefore, as well as the police system, if we have to ensure that criminal cases pendency comes down.
Thank you very much.
I would add 2 or 3 things. Firstly, I would add to what Justice Bhat said, that every time when new law is created, there are new courts established. But the fact remains that the present judges only have to deal with those cases which are under the special acts. So whenever there is a new law, new courts, there has to be a new establishment to deal with those cases. Secondly, we need to change our mindsets. Most of the times, the court machinery is being used, or rather misused, just to harass the other side. So there are so many stakeholders in the present system. Our traditional legal system probably needs to be drastically changed. And one more thing I would like to say is that we need to use more and more the artificial intelligence machinery and the digitization of courts. There are so many things. Supreme Court at the helm is undertaking many projects by which there has been a smooth transition of data and information all throughout the country. But that process will be very, slowly getting the result. And till then, I think we need to have some deterrence of the court that if you do something wrong, probably that will not be tolerated. Thank you very much.
Thank you very much, Justice Trivedi, and your
Just
concluding.
3 points. The state is the biggest litigator. And inaction or arbitrariness on the part of the state also results into litigation. Each state, I only wish the solicitor was here, have their state litigation policy. And that litigation policy must be implemented. A, it must be, people must be made aware of that policy. B, it must be implemented in letter and spirit. C, you must use technology to bring in transparency. For example, have a website where people can lodge their complaints vis-a-vis, be it commercial contract, be it an individual dispute, and the timeline within which the dispute resolution mechanism, as per the litigation policy, is adhered to. Another thing is that whenever a new legislation comes in, the impact that legislation has on the judiciary, there has to be an assessment prior to that. Unfortunately, that is not done in India. I would say that. Thank you.
Thank you very much to our very distinguished judges, Justice Surya, Justice Ravindra Bhat, Justice Trivedi, and Justice Sanjay Karol. We got an absolute treat. I don't even want to summarize what has happened. The last 75 minutes has been truly inspiring, and we are deeply grateful to our judges for taking out time on a Saturday morning, as well as having prepared for the session and being here. My apologies for the next session, but since several of you judges have spoken on about digitization, we have with us none other than Dr. Saurabh Garg, the Chief Executive Officer of Unique Identification Authority of India, UDAI, who is here, who will be delivering a special address in this session on globalization, balancing digitization, and right to privacy, India, US, and Europe compared. This session is ended. We have some certificates to be distributed. So
I would like to thank all the panelists for a very informative discussions. Now we'll move ahead with distributing the mementos. So we have Mr. Nishit Desai and Mr. Ajay Bhargav for distributing the mementos. I would invite you on the stage, please. Justice Ravindra Bhat. Just next. Justice Bela Trivedi.